David Parker.
Mr. Chairman, thank you to the attorney for his contribution then. For those who are on radio, the man who just made reference to pettifogging on this cold Wellington day has not got his fingerless gloves on, although rumour has it that he's still sort of busy trying to finalise those appeal documents for Aldice versus Aldice. Which of course was the famous case in Bleak House. Mr. Chairman, I'm not going to go into the detail of the bill at the committee stage. I agree with the attorney that these issues as to detail in the bill have been well traversed. I want to make a brief contribution about the overall principle, because I think that is what lies at the heart of why the Privileges Committee has thought it necessary to codify parliamentary privilege. Mr. Chairman, the relationship between the courts, Parliament and the Executive is a very, very important one. In my opinion, how we do that in Westminster democracies is, or history shows that the way we do it in Westminster democracies, like New Zealand's democracy, is the best way it is done in the world. We do it through respect for the limits of the respective jurisdictions of different arms of democracy, or different institutions which between them uphold and ensure that democracy endures. Occasionally, one part of democracy rubs up against another in a way which the other part thinks goes too far. And as I've said in an earlier contribution, I like the fact that we don't try and codify everything, because when those things happen, I think that if you're a mature jurisdiction that has respect for traditions, for the conventions that we have for the rule of law and for human rights and for the separation of powers, you can effectively, it's not negotiate your way through, but find a path through that is wise and everyone can live with. On this occasion, we are dealing with a situation where, in the opinion of Parliament, the judiciary went too far to limit the rights of the privileges of Parliament. And we, in support of that logic, go back to the 1688 Bill of Rights, when these divisions between what was then the King and Parliament, and also at around the same time the relationship with the courts, were being formalised and have have stood the test of time for over 300 years since. And one of the principles in the Bill of Rights is set out in Article 9 in very brief form, and it says that it protects the freedom of speech we have in Parliament. It says that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. And Parliament, in respect of two decisions, the Attorney General and Gow and Lee and Buchanan and Jennings, thought that the court was constraining Parliament's rights under Article 9 with those decisions in a way that was undesirable. And as has been said in earlier stages of the proceedings, those privileges don't exist to make life easy for parliamentarians. That's not their purpose. They exist in order to protect the ability of Parliament to do its work for the sake of democracy. And we all know, or I think everyone in this House accepts, that democracy is such a complex web of settings, not all of which can be written down in constitutional documents, but when taken together, those ingredients, that complex mix of ingredients, means that you have a peaceful, happy, prosperous society that is fair to the people who live in it. Mr. Chairman.
David Parker.
Mr. Chairman, thank you. As a consequence of the decision in Gow and Lee, the Parliament believes that the advice that ought to be available to ministers as they prepare for question time, and that was the subject matter that lay behind the Attorney General in Gow versus Lee, the information that's made available to a minister at question time should be all of the information that officials have and can bring to bear, and we don't want those officials to edit what they know because they might fear they could be tied up in some proceeding. And we don't accept the view that because they might have qualified privilege as officials, they wouldn't be less open than they would be with ministers if they had absolute privilege. And so we, in this Parliament, think that it's important to protect the information that comes to ministers for question time and therefore ensures that the public get an unedited view as to what their leaders, who have been elected to Parliament, can say in respect of issues of public interest. And if that is defamatory of the rich and famous in society, well, so be it. And on occasions, that's right. On very rare occasions, a member of the public may suffer an injustice by being defamed by a parliamentarian and having no recourse for it because it happened in Parliament and it was absolutely privileged. And that might have been occasioned by an official within government giving advice to a minister to that effect. That is the price that we pay to have an open democracy that enables, through this Parliament that has freedom of expression, to actually make transparent things that might be going wrong in society and therefore make sure, for example, that corruption doesn't creep into our system. And we've actually seen events in recent years where we've had some very litigious people arising out of some of some very wealthy people, in particular in relation to Hanover Finance, where many hundreds of millions of dollars were lost by New Zealand investors and finance companies, and allegations were made as to improper behaviour on the part of some of the directors. And those people who made those allegations outside of Parliament were subject to legal suit and are being. Indeed, Mr Brian Gaynor was one of those ones who, notably as a financial commentator in the Herald, has been sued for defamatory comments. Now, those same sort of allegations ought to be able to be made in this House without fear of risk of defamation, and that sort of information, if it's held by a public official, and they're the ones that look into these things often, that should be able to be passed to a minister and be used in this Parliament, and if it is used by a minister in this Parliament, it should be absolutely privileged. And this bill addresses that situation by returning us to the law as it was before the decision in Attorney General and Gow and Lee. We think a mistake was made imputing into parliamentary processes these doctrines of necessity, which seem to be in part taken from the point of view of us in Parliament, from a view that defamation concepts should be imported into our parliamentary privilege law. And it's actually one of the reasons why, in terms of the drafting of the legislation as to the principles behind it, at Select Committee we took out reference to the defamation language in the bill to make it clear that this isn't actually about defamation, it's about parliamentary privilege. The second part of it is Buchanan and Jennings. I'm not going to cover that in detail, except to say that I think most people thought it was silly that a Member of Parliament could say something privileged in Parliament and could not say outside the House, well, I don't resolve from that, if asked the question, do you resolve from that? And, obviously if a Member of Parliament repeats the defamatory statement outside of Parliament, it is a new defamatory statement and they ought to be able to be sued in defamation. But for a Member of Parliament not to be able to say, well, I don't resolve from it outside of Parliament, and for the courts to effectively link the I do not resolve from that, which is not of itself defamatory, to link that to statements made in Parliament to make the I do not resolve from that a defamatory statement, was actually, again, a misunderstanding of the privilege that we allow the courts to refer to things that happened in Parliament in a way that actually we didn't originally. And so we're again returning that law to where it was before the decision in Buchanan and Jennings. And I think again we will be protecting the reputation of democracy, because in the end, actually, we need people to respect politicians and what we do in this House if we are to have respect for democratic institutions, of which we are an important part. And I think it made politicians look foolish if they can't say outside the House, well, I don't resolve from that, because otherwise it looks like they do resolve from it when in fact they don't. So, Mr Speaker, I think this is an important piece of legislation. Can I thank again all of the officials? Can I thank the Attorney for bringing it to the House? And I have nothing further to add, sir.
I'm going to call Dr Kennedy Graham.
Thank you, Mr Chairman. I think it's pleasing to mark the